Voulgaris and his latest book, The ICJ and Multi-Forum Litigation Strategy. So Nikolaos is Professor of International Law at the European Law and Governance School. He's an adjunct professor at the Law School of the National and Kapodistrian University of Athens. He's a fellow at the Centre of International Governance and Dispute Resolution at King's College London and the Athens Public International Law Centre. And he's been doing a mini book tour of the UK over the last couple of days in some of those places. He was also my doctoral student more than 10 years ago, and he actually, this is his second book because he published his doctoral thesis as a very well-received book with heart entitled Allocating International Responsibility Between International Organizations and Member States. But we're here to discuss the ICJ and litigation strategy. And I'm going to first ask Nick to give us a 5-minute overview of his argument and the book. I've then got a few questions for him, and then we'll open it up to the audience. So, Nick, introduce your book. Welcome.
Thank you. Thank you, Philippa, for having me. Hello to everyone, and thank you for being here. So, I have been on tour indeed. So this is the third presentation of the book, but I haven't managed to do it in 5 minutes yet, so this is quite a challenge. First of all, I want to sincerely thank Philippa for being kind enough to write also the introduction to the book, the first page. So, I want to make 2 claims in my 5-minute introduction. The first one is that my attempt with this book is to put my feet into the ocean, not the sea, of political sciences. And I'm not a person that has been trained in political sciences. I have a legal background. Nevertheless, and especially in the present juncture, that international law is being questioned by so many angles, and it has become so pertinent and relevant international discourse. Not necessarily international legal discourse, but the political one also. I think it becomes increasingly relevant to understand the function and the operation of international courts, the ICJ is one of them, from a multi or interdisciplinary perspective. And this is an attempt that I'm trying to actually do with this book. So, a question that underlies this book is, why do states choose to engage in such a litigation strategy? Why do they choose to engage more than one judicial fora to adjudicate the same factual matrix? So, we cannot, in legal terms, talk about the same dispute, but more generally speaking, so the same factual matrix, which is at the end of the day a political question, because the factors that motivate a state to pursue this strategy, they can be deriving from a domestic point of view, domestic perspective. They could relate to the diplomatic relations of states. It could come from wherever. So what I realized is that we experience a phenomenon that we can understand as the judicialization of politics, which means the increasing recourse to judicial formation, judicial institutions, to regulate or to have a saying on political issues, and this leads or has led to a politicization of justice. What do I mean by that? Is that this tendency or this trend to use prolifically international judicial institutions embeds to the users of international courts, states, an understanding that it is okay, and it's not only okay, but the role of international courts is slightly shifting beyond that of a legal dispute settler. And because international courts can perform many roles at the same time, they have one function, which is to, legally determine a dispute, if we're not talking about advisory opinions, of course. But they can perform many roles. And just to name a couple of them that are attached to their, if I can call it, political functioning or political roles, is, for example, to be used as communication media. They're a very good platform for a state to communicate their claims to the international community. For example, ICJ hearings are getting live coverage. There is extensive, journalist coverage from journalists as to what happens before the court. Newspapers are writing about it, so this is a good platform on the one hand. And on the other hand, judicial judgments and judicial outputs, either we want it or not, they produce history. So they're good enough, a good way, a good means to create a narrative. And I'll finish my 5 minutes with one example. So when the head counsel for Ukraine came out of the Peace Palace after the preliminary objections judgment, he said to the cameras that we're happy with this judgment where practically all Ukrainian claims were deemed, the court was not going to deal with them except from the reverse compliance claim. So he said, that's good enough for us because we're going to debunk the myth that we committed genocide in our soil. Of course, they could score an own goal in this sense, but this testifies as to how Ukraine wants to utilize/instrumentalize the court as the creator of a certain particular narrative. So, my last sentence. So, I believe that multi-forum litigation strategy is one of the many indicia that international courts are increasingly instrumentalized for reasons that go beyond their legal functioning or their legal dispute settlement role, and this puts forward an alternative understanding or a perversion of the role from legal bodies to political ones.
Thank you. And we're going to come back to that Ukraine example in a moment. But I wanted to just start with this concept of multi-forum litigation strategy. You distinguish it from lawfare, for example, or more classic strategic litigation. But how do you draw the boundary between a legitimate legal strategy and practices that undermine the normative authority of international courts like the ICJ?
Thank you for that.
By the way, Nick sent me 5 questions and I'm not using any of them. So this is spontaneous.
Okay, so I do disassociate myself from these two concepts. That's right. There is an article by Bill Shabas in an American journal, and he had the audacity, I dare say, to, in the title of the article, spell the word lawfare with Scrabble tiles. And he claims that the only use of that term would be in a Scrabble game, even though I don't know whether my partner would object. What's his point? His point is that terms such as lawfare and strategic litigation don't have a fixed concept. They're very relaxed notions that can be used by different agendas. For example, Israel is using it in a negative connotation when it refers to what Palestine is doing by using international courts, essentially saying that Palestine is abusing courts by exercising lawfare against Israel. On the other hand, Ukraine, I don't know if you're aware, but Ukraine, the Ministry of Justice of Ukraine created a website it called Lawfare, whereby in that website it actually made a map and it highlighted all the different courts where it used lawfare as a strategy. So for Ukraine,
they call it the web of accountability, I think.
There you go. So for Ukraine, lawfare is a positively charged notion, but for Israel, it's a negatively charged one. So because I wanted to make, as I said before, an argument that's also political, my basis, I wanted my basis to be something as descriptive and not normatively charged. I wanted to have a solid background or background understanding of what is the typology of cases I'm dealing with. So lawfare, again, could be something that it's, so prone to abuse, and I didn't want that as a
But where do you draw the
element.
line between what's lawfare and what's a multi-forum litigation strategy?
So multi-forum litigation strategy is something, in my understanding, purely descriptive.
Right.
Which
So
means
it could be lawfare in the way that some of these
I don't
states
care if
using
it's
it.
lawful or not, because I don't engage with this
Right.
with this debate.
Yeah.
Because I guess nobody knows where lawfare ends and where lawfare begins. I completely discard dealing with this. So, and I say that as long as you have one actor pursuing multiple litigation before legal fora or judicial fora, then this is good enough for this case to fall within my ambit of cases that I look into. And I identified, if I'm not mistaken, 10 or 11 of them that fall under this category.
Yeah.
So, yeah.
Many of which are ongoing. Okay, so in your introduction, you say lately the International Court has been highly relevant in adjudicating global affairs, as relevant as it has ever been. As I'm writing these lines, facets of the three deadliest conflicts of 2024, Ukraine, Palestine and Myanmar, are being examined by the court. And indeed, the Gambia-Myanmar case is being heard right now in the Peace Palace on the merits. But since then, so even since you wrote those lines in 2024, we've had certain world leaders say international law is dead, we need a new legal order, we are guided by one person's personal morality, and so on. What is the role of the International Court in this moment of rupture? So what is its role, since you like empirical, and what should its role be?
All right. What is its role? I believe that the role of the court should be guided by its statute and by its function. So its role is to, let's say, provide a legal understanding or legal estimation of the case brought before it, without at the same time, attempting or knowingly engage into policy making, because that will make the court prone to criticism by whoever. That in fact, it's doing things it's not supposed to be doing. And I think the judges of the ICJ have been lately, quite careful not to, let's say, make any obiter dicta that go too far, or to suggest political solutions to the problems put before them. Even though I'm sure that they are all very aware of the political ramifications of the disputes brought before them, I think they're being quite cautious.
Since what date?
Since what date they've been cautious?
Yeah.
I would say after Kosovo.
We'll come back on that.
Okay. Some people could say that Chagos was also them not being very cautious, but I think the problem with that opinion, I don't know if I'm like jumping ahead, something I wanted to ask, the problem with Chagos was how the opinion was perceived by others, not by what the court exactly said in that opinion. And also the climate change opinion, I'm pretty happy with that outcome. So,
So, and what it is doing and what role it is performing, is that also your should? It sounds like you're happy with how the court is.
Yes, I'm quite happy actually at the moment,
So we're sitting here in a school of government. How do you see states approaching the court to advance certain policy positions? So as you were saying, the court's not engaging in policy making, but states may be using the court for certain policy outcomes. In fact, I'm sure they are. So how do you see that unfolding through these multi-forum strategies?
Okay, let's just agree that, as you said, this has been the case. I mean, states pursuing political objectives via international courts since, I mean, the dawn of international courts themselves. I mean, they have been used politically forever. What I think is the extra, let's say, value of a multi-forum litigation strategy politically is that creation of a narrative. So states attempt to circulate, if I may, their claims before different fora, to project their opponent as someone who is actually being, whose conduct is frowned upon by not one, but like many institutions that represent somehow international law and therefore the international community. So and this is, I believe, the extra layer of instrumentalization that we experience with multi-forum litigation. So it's the portrayal of a state like Russia or Israel or whoever as an outcast to the international community, and we're using as many for as possible to actually do so.
So I want to, so still staying on that, the sort of use of the court in advancing certain policy positions, I wanted to focus on provisional measures for a moment. Now, provisional measures are when the court can issue like an emergency injunction. So usually an ICJ case takes 4 years on average for contentious cases from the application until the judgment. But if at the time of the application a state puts in a request for provisional measures saying that there's irreparable harm that's going to, and there's urgency, as well as a plausible connection to the rights in issue, there can be a hearing within a couple of weeks and a decision within a couple of weeks. So it's a very sort of powerful tool from a timing and narrative control perspective. And then going back to you saying Kosovo was the last time the court engaged in policy making, perhaps. But I would say when the full-scale invasion of Ukraine broke out in February 2022, Ukraine was in that court on provisional measures 2 weeks later, or even a week later.
No, even less than
I think it was a week later. And there was an order on provisional measures another week later. Now, Ukraine brought that case under the Genocide Convention, and in its request for provisional measures, it said for the court to order Russia to suspend military operations that are associated with, potential violations of the Genocide Convention. The court, in its provisional measures order, said that Russia had to suspend all military operations, full stop. No link to the Genocide Convention. Is that not a politicization of the court?
You mean by the court itself?
Yeah.
So I understand the criticism that the court went too far by these political measures. Nevertheless, given the stakes of the case, I can understand, even from a legal point of view, and I mean the extraordinary scale and effects, if we can call it like that, of the situation at hand, I can understand the court's perspective that if the court were to give a more nuanced opinion, then maybe the nature of, it would have taken such a long time that a provisional measures order would have, been given maybe a couple of months later. So the idea of giving a provisional measures order would have been lost, as a provisional measures order.
But it hasn't been complied with.
No, of course not. No. And the judges knew that it was not
so
going to be complied with. So then why are they thinking
it's important we do this in a week and not in 2 months if it's never going to be complied with?
So that the court still remains relevant in regulating global affairs, so that it actually responds in the way it's supposed to an ongoing situation in a timely fashion, in a timely manner.
Are you revising your claim that it was only since Kosovo that the court is engaged in policy making?
Well, I say I can understand it, and I don't think it's legally implausible to do so. There were political considerations, of course, as there are always. But what I'm saying is that the court, I wouldn't attack the court and accuse it of being, engaging in policy making, or that policy making has been the first consideration in the minds of judges, but also, for example, in upholding the judicial nature of this proceedings we call provisional measures was also very pertinent there. So I think this is a good justification for the court's approach there, if that makes some sense.
Yeah. I'm just going to ask one more question, then we'll open it up. So we've got, this is just some of the sort of brewing conflicts or actual conflicts around the world. Greenland, Taiwan, Ukraine, Yemen, Sudan, Gaza, none of which the court has been effective in addressing, or even I would say multi-fora have been effective in addressing. With that reality, are you still optimistic that courts are an important part of dealing with these disputes?
I don't want to change the question. I am, but I believe the most important thing here is that even if we're not optimistic, we should be. And I think we're on the same page on this because, I finished the book by citing an article that you wrote from the Australian Journal of International Law that, hope should be the main sentiment, the main feeling that should animate our attitude towards international law and the upholding of the international rule of law. And I strongly side with that. Some months ago, in this same room, you had a presentation of a book on international law stories.
Yeah.
I followed that, and I believe that since international law is made up of stories, and I deeply believe that this is a book I'm giving away to my students, we should be very aware of the stories that the next generations are going to discuss and talk about for our present times. And if the feeling that, I'm saying it again, that it's the prevailing one amongst people that believe in the normative force of rules and of international law, the main feeling is hope, and this is what guides us, then I believe there's a chance that those stories can be full of hope and therefore able to make a change in as to how actually now international law is felt and criticized around the world. So I am an optimist, but again, I think this is the stance that we all should have as things stand.
Thank you. And if we have time, I may come back to some of those concepts, but I want to open it up to the audience to ask any questions. Please let us know there's a microphone coming. Please let us know who you are, Maurice, for the benefit of everyone
My
else.
name is Maurice Mendelssohn. I'm an emeritus professor of international law, but I'm currently a practicing King's Counsel in international law. A couple of points or questions, if I may.
Yes.
First of all, I think that it would be helpful to distinguish between judicial policy and courts making politics. And I think that there is no shortage of examples of the ICJ making judicial policy. For example, Article 41 of its statute, if I remember the number correctly, says that the court may indicate provisional measures, and many people have thought for a very long time that simply meant recommendations, not binding decisions. But the court was persuaded, I think probably by Ros Higgins, about 20 years ago or whatever it was, in those consular cases against the United States, that they were binding. Now that seems to me to be judicial policy. It's not politics as such. I'm not saying that they were taking the side of one country or the other, but I'm saying it's judicial policy. Similarly, the reparation for injuries case might be said to be judicial policy rather than playing politics. I'm certainly not saying that judges on the court are immune from playing politics. There have been some very egregious examples of that. For example, the way that the president of the court persuaded the court that an agreement between Qatar and Bahrain and Saudi Arabia, that if Saudi Arabia couldn't mediate resolve a dispute between them within a certain time, the parties could go to the court. And declaring an interest here, I was one of the counsel for Qatar, and when a Qatari official waved this piece of the translation at me and says, look, it says we can go to the court unilaterally, my reaction was, I don't speak Arabic, but is there a dual form in Arabic? And the answer was yes. And to me, that meant, and to a number of people, it meant that the parties had to go hand in hand, not unilaterally. But the president of the court, I don't know quite
At the time,
yes, decided, persuaded a majority of his colleagues otherwise. Now that seems to me to be politics, and I think one can find other examples of that. But the court as a whole playing politics, that is, I agree, rarer for now. Let's hope it continues, but I'm not sure. But if you look beyond the ICJ, at, for example, you mentioned this, the Tribunal on the Law of the Sea, that was either, I think, political, its decision on the Chagos Islands was either political or was very sloppy legal reasoning. Anyway, the other thing that I didn't quite understand was the distinction you seem to make between purely legal disputes and political disputes. I mean, I understand that there are political disputes which are not legal at all, you know, if the dispute is about what should happen in a optative sort of way. But surely when states bring cases, and even when, if you widen it beyond the ICJ, if investors bring cases against the state, they're not doing it just to academically, as it were, resolve an interesting legal point. They're doing it because they want something out of it. And they want, coming back to ICJ litigation, they want a result which suits them either politically or financially or in some such sense. And incidentally, if I can just interject a story, a quick story. I was, as I've said, counsel for Qatar, and various people who knew me knew I was in that case. And they said to me, oh, is there oil or gas there? And I said, the biggest gas field in the world is offshore those two countries. So they nodded sagely, you know, as if that explained why they were litigating. And I said, no, the real reason, this is Chatham House rules, of course.
Chatham House rules, yes.
They're litigating is that the two ruling families have hated each other's guts for 2.5 centuries. And the gas, which is hugely valuable, is just a kind of sideline. So, you know, there are all sorts of reasons, but I think that states never bring cases just because they want a legal point resolved, or hardly ever. I mean, there may be more of a legal problem, or it may be more of a political problem. But anyway, so I was, sorry, this is rather long-winded, but I was just puzzled by your basic premise about what the distinction is, but it's probably my lack of understanding.
Or it's your next book.
It's me. Okay. So the first point, thank you, yes. Judicial policy versus courts making politics. Judicial policy, I mean, given the example that you gave, is I understand the discretion that the court has to interpret or to, let's say, make sense of the powers that it has. And I think this is even more evident in advisory opinions, where the court has the discretion not to answer a question if it wants to.
Which is, it's exercised twice.
Yeah, but not for the reason that the question is, let's say, not legally resolvable because of the nature of the question,
True.
but because the court's, let's say, the scope, let's say, of the court's, how do you say this?
Competence.
Yeah, the competence. Yeah, the organ that brought the question to the court was not the appropriate one.
Yeah.
Let's say. So, and I bring this example in the book when I contrast the practice of the International Court of Justice with that of the Inter-American Court of Human Rights that has provided many advisory opinions, interstate ones, I mean, and the Inter-American Court is willing to say no to some requests for advisory opinions because they are either too politically sensitive or they essentially are a masked dispute between two states that should be brought in another way. The court never does that. The court is actually very willing to undertake any question, see Kosovo, even to reformulate the question in order to undertake it, even though it could very well dismiss questions, for example, Western Sahara, that essentially are about a bilateral dispute between states. So I fully agree with the distinction, and I think that courts making politics part or aspect is the problematic, or maybe the problematic one. Now the second distinction you made, I'm not sure that I did it. What I basically say is that multiple factors may animate a state's decision to pursue judicial proceedings, all the more a multiform litigation strategy. I fully accept the point, and I agree, and I think I'm saying this in the book, that political reasons and legal ones may coexist. What I think is the case lately is that political reasons are being prevalent, and especially those reasons that are attached to viewing courts as political organs, to using, the term I'm using is instrumentalizing courts for the pursuance of political objectives via them. So the court is used as a de facto security council, as a de facto political organ. That's basically the claim here. Yeah.
Next questions. I'm going to take a couple. So Jackson, then Dana. Jackson.
Hello, my name is Jackson. I'm an MPP student here at Oxford. First off, I want to thank you for coming today and doing this book talk. If the sort of trend of the politicalization of the judiciary continues, in your opinion, what do you believe to be some of the big consequences of that, positive or negative? Thank you.
And then over here, yes, just behind you, Dana.
Thank you. I'm Dana Wagner. I'm a fellow here at the Blavatnik School, and I know woefully little about the ICJ, so I really welcome this conversation and appreciate your book. I was struck by your comment that the court felt a need to weigh in quickly on the Russian-Ukrainian situation, even knowing that its decision would likely be disregarded because it wanted to preserve its relevance. And I mean, it strikes me that like blowing the conch shell in Lord of the Flies, if you know no one will listen to it, that issuing a decision you know would be disregarded could threaten your relevance in the perception. And so I'm curious about the ramifications of that, and more broadly, if there was a perception that the most powerful nations in the world are likely to disregard decisions of the court, what does that mean for its legitimacy and the willingness of less powerful nations to buy into it as a means of, as a legitimate authority and a means of dispute resolution? So I'd welcome your thoughts.
So over to you.
Over to me.
Yes.
So, can I read like 3 sentences, literally 3 sentences from the book, because I think they will answer your question. So,
conclusion.
Yeah. The overuse of a pivotal international judicial institution as a political medium can produce bad international law coinage. In turn, this may impact international law's capacity to be understood as a mechanism creating normative commands. We are far away from this grim picture today, but in the era of whataboutism, the relativization of the normative value of rules may come about at a fast pace. So I worry, yes, that this erosion of the legitimacy or authority of international institutions may pivot to the authority of international law as a system that demands compliance from its users. Again, the erosion of a court's legitimacy is not something that happens overnight. It takes a long time. Nevertheless, in the prolific way that international law is being used in political discourse today, I think, and the attacks, to international law coming from many sides, I think that this erosion of international law generally as a system could be accelerated right now. So this is what worries me at the moment. And I think that these words stand, I wrote in December 2024, so I think this still holds true.
Well, we're only a year and a bit later, but it is moving fast.
Yeah, things are moving.
Yeah. I mean, even just since the 3rd of January, it feels like a lot has happened. And then
yes,
to Dana's
so
question.
thank you for that. What are the ramifications of non-compliance with ICJ judgments on the court's legitimacy? I think, it's pretty evident that no court wants its decisions to be disregarded, and if this is done, this does not do any good to its authority or its legitimacy. But the ICJ sits upon an 80-year history. All I'm saying,
Even 100 years if you include
the PCIJ,
court,
of course, yes. So there is some type of institutional memory in these issues, and something that the court has built upon many years now. That's all I want to say. But there are 2 issues here. First, as long as the court is being careful and does not, go further away from what it's supposed to be doing, it does anything it can to preserve this authority. On the other hand, there is something the court cannot control, and this is how it is viewed, how is it seen by the broader international community. So, which seems to be the case lately, that the court is increasingly seen as a political body. I agree with what you said. This could potentially be something destroying the court's authority. We're not there yet. But we'll see what the future comes to hold.
And Dana also said, what does this mean for less powerful states wanting
or
avoiding the court? No, it's a follow-up point. Yeah.
It is being said that the law is the tool of the weak, and I fully endorse that. Relativizing the authority of the court would definitely mean that the position of those states is being weakened even further. But I'm sure you all followed the talk by the Canadian Prime Minister some days ago. About what middle states or even weaker states should be doing in this juncture, and I sort of agree with what he's saying. And it also falls upon international institutions, judicial institutions, and how they're being used by those states to get into this diplomatic game, if I may say so. So, yes, weaker states should worry about this, but it's also in their hands to, conserve the authority of those institutions. I think
And
the way they use it. Yes, of course.
I know we have a question here. We'll start here.
Hi, I'm Sarah Tugas. I'm a visiting PhD student from Sciences Po in Paris. And I'm coming from the political science point of view, and I had a question about the ICJ advisory opinion on climate, because I work on climate negotiations, and this has been recurrently sort of brought into international climate negotiations, especially by smaller and most vulnerable states. But I'm wondering whether this would be producing an actual effect in the negotiations themselves, and bringing them towards sort of responsibility of the most polluting states, and if you think they will react to this. And if not, if individual states would start litigation cases against other individual states, if this could be happening, and the consequences that this will have on diplomatic relations and the international negotiations themselves.
Great, and I think we've got 2 questions here that we'll take as well in this round.
Thank you.
Hello, I'm an MSc student here at the school. My name is Alejandro. I was wondering if you could elaborate a little bit more on how should courts strategize back? Because you have said something that I think I agree totally with, which is courts should stick to their functions. But I wonder if they could do, in your opinion, something else to respond to the criticisms, to respond to the instrumentalization, to respond to this narrative that they have become politicized institutions. Thank you.
Thanks. Graham Turnock, visiting fellow at All Souls. I'm quite interested in your view on the importance of court judgments, not in the sense of whether they're sort of respected directly by the parties, but whether they serve as a platform to legitimize other actions by other states. So in the case of Ukraine, I guess arguably one could say that the ICJ judgment strengthened the hand of those wanting to take sanctions against Russia. You know, is that a good thing for the legal system, or is it essentially undermining it if actually it ends up having impacts through, you know, separate political actions?
Okay, it's on me now?
Yes.
Wow, okay.
I can remind you as well.
Good. No, thank you all. May I start with your question, Alejandro? How should the court respond? I mean, aside from the fact that, you know, it should not engage into policy making, I think that the ICJ must be an actor that is present in the in being how do you say this? In making its work known to as many audiences as possible. So I like the fact that the court, for example, has a LinkedIn account and it's, you know, very visible as to what it does. So I like that the fact that the court is being as transparent as possible towards the international community as to what is happening there. And it's communicating its work, again, with the most openness that it can. So I think that's the most that it can do at the moment. So be as transparent and open as possible with what it's doing. And because, again, maybe I'm too conservative as to the institutional functions or the roles of courts, but I think this is good enough. The court speaks through its judgments, and it shouldn't not go anywhere beyond that. I hope that is a sort of an answer.
Can I just add an anecdote on that? So when I was legal advisor to President Rosalind Higgins at the court, and we had the Bosnia genocide case where Bosnia was alleging that Serbia had committed genocide during the Balkans conflict. The judgment of the court, because they could only go through the lens of the Genocide Convention, so there was extensive evidence of crimes against humanity and war crimes and horrific, you know, prison camps and so on. But the court had to look at the strict wording of the Genocide Convention. So in the end, they didn't find Serbia responsible for the commission of genocide. They found Serbia responsible for breaching the obligation to prevent and punish genocide. And that's a very fine distinction in law and in the Genocide Convention. So President Higgins decided to have a press conference. So she gave the judgment in court, and then she actually crossed the Peace Palace to the small court of justice, so not in the same room, and had a press conference, which was really not for her to explain everything again, but it just an opportunity for journalists who were there to ask questions. And they were all about, why didn't you find crimes against humanity? And she's saying, our jurisdiction didn't extend to that. I thought that was helpful. I But I don't think it's been done since then, and it's not something you've suggested. Do you think that's a dangerous route?
You mean
To engage in a press conference with journalists, not just
not at
post
all.
the summary on
Not
LinkedIn?
at all, not at all. As long as this clarifies some points and don't, allows that judgments are being treated in the press in the wrong way, I fully agree with that.
Okay.
Yeah.
So that could be another way to make their work known.
Sure.
Yeah.
Sure.
Okay, but you've got more
Yeah,
questions
I do.
to deal with.
I think it also links very well with your question. The court cannot control how its outputs are going to be used later on by the international community. So yes, they may weaponize, in a way, as you suggested, third states to use them, as they see fit. I fully agree with that, and that is a risk that we have to take into consideration. But that is, again, beyond the court's control, something that is always the case. But when Ukraine is deliberately using the court to show its alliances with basically most of the Western world, and it's instrumentalizing the procedure of interventions before the court for that matter, and not for the purpose they're used for, to actually infer something new to the legal debate. And, basically say to Russia, listen, I'm here with the rest of the world and you are alone. So, yeah. So Ukraine is not helping this cause, the way it's using the court. So that's why I answered before to that question, saying that it also falls upon states as to how they use institutions in an appropriate manner, so that this type of reaction, like the one that you mentioned, are actually not so easily triggered. But again, there is only so much that the court can do in this respect. Now, climate change, I have no good answer to that, honestly, because this is a deeply political question. Again, I have no training in political sciences. Will it affect international climate negotiations? They are going, as far as I know. Well, I hope it will. Again, the only thing that I can go with is the authority of the court, and how advisory opinions are being perceived by the international community. And following up on Chagos, there is a good precedent that, yes, they are actually going to, but we see attitude of states like India, for example, or China. How hopeful can you be that this is actually going to be the case? The creation of a narrative here is what plays an extremely significant role. Again, I am hopeful. But beyond that, I really cannot say anything else. I'm not competent also to say anything else. But I'm sorry, it's not a good answer, I know, but it's the only thing that I'm entitled to say at the moment.
I can chip in.
Please.
I represented COSIS in the ITLOS proceedings and Tuvalu in the ICJ proceedings. But I was not in the COP30 negotiations, so I don't know how the case was being used, the judgments were being used, well, the opinions were being used in those negotiations. But what I can tell you, what the multi-forum strategy behind that, at least for the states I represented, was that this is just a first step at the ICJ, and they didn't expect a big impact on the negotiations, but they said if we can at least get the court to say that the ILC articles on state responsibility apply, which they did. If we can get the court to say that if a state loses its territory, it continues to be a state, which the court sort of did, but more so than not. If we can, in the ITLOS proceedings, and Jack, who's here, was in those proceedings with me, if we can get the court to say, that there's not just an obligation to prevent or reduce emissions, but there's actually an obligation to restore marine environments, which they did. These are all tools that start being added to the toolkit. But, again, to be in a negotiation with India and China and say, oh, there's this opinion that says, we need to get to 1.5 degrees, it's not going to carry much weight. It's a more nuanced, multi-forum, multi-stakeholder strategy. Okay, one last round.
One sentence. The important thing is that you increase the pressure in this way.
Yeah.
By engaging more and more, institutions to have a saying on this, and that's the only thing you can do.
Yeah. So,
wow.
Okay, I'm going to take all of them, and then you're going to answer very briefly. Okay, Leia. Yes.
Thank you.
There'll be one line to each.
Good.
Hi, I'm Leah Leonhardt. I'm a BCL student here. And I was just hoping for a clarification on your argument. So I understand that you're criticizing states for increasingly instrumentalizing the court. But does that necessarily entail a reduction in the quality of the legal argument or the legal cases brought? Because it does seem to me the premise of your argument saying that there is an erosion of the international legal order. But if it is true that there's not necessarily a link, does that affect your argument at all? Thank you.
And then Jack beside you.
Hi, I'm Jack. I'm a student here and a researcher at the University of New South Wales. I was just wondering, what should we think about the way in which the courts and tribunals that are seized of this multi-forum litigation strategy, how should they interact with each other? How should they interact with each other's judgments? Obviously, it was highly beneficial in Chagos that the Special Chamber was able to rely on the advisory opinion. Quite helpful for the ICJ to be able to rely on the ITLOS and Inter-American Court of Human Rights decisions in the climate change advisory proceedings. What guardrails do we need on how these courts interact with each other, if any? How should it be done?
Other hands? Yeah. Jackson, you've already had a go. Over here, please. Yes, this gentleman.
Thank you. Mark Lodge from the UK and Ireland Global Cancer Network, but this is not about cancer. There was a very good talk here 2 days ago by Anne Applebaum, Autocracy Inc., fantastic for those of us who are able to attend, talking about the new autocrats, the Trumps, the Russians, the Chinese, and so on. Critics of, amongst that group, I want to take you to the dark side. Critics of the International Court of Justice and other arenas, have they proposed an alternative, or have they just said, this isn't working for us?
Alternative to the UN?
Alternative structure or alternative way of doing things that's as opposed to what we have.
Yeah. And Kaylin?
Hi, my name is Kaylin. I'm an MPP student here as well. To reference Professor Webb's work, I was wondering to what extent this forum shopping is leading to judicial fragmentation, and if this is just a natural consequence of any sort of legal system.
Me?
Yeah.
Okay. One sentence. All right.
No, 2 sentences. 1 minute.
Reduction in the quality of the legal argument, not necessarily, but there has been an increase in the objections by states before the ICJ for abuse of process, which means that there's an increasing criticism that the court is being dragged to deal with a dispute when it shouldn't be doing so. So, I mean, you could say that, yes, states are, making arguments when they don't exist, and therefore they're trying so hard to engage the court, which necessarily entails, what you call the reduction in the quality. So, yes, that could very well be the case. Interjudicial dialogues.
And that sort of goes with Kaylin's question about fragmentation.
I guess.
Yeah.
I guess, yeah. I don't treat judicial fragmentation as a phenomenon that triggers multiforum litigation rather than the other way around. Because states have in their mind that we want to go everywhere, this is the objective, and the necessary implication of that is that we have to fragment our claims to different courts. So I don't see fragmentation as the offspring of multiforum litigation strategy, but the other way around, if that makes sense. Interjudicial dialogues. This has been very fashionable 25 years ago. Should courts communicate between each other? This discussion is no longer a la mode because there is some coordination between how courts treat these issues, even though institutionally this doesn't happen very clearly. Nevertheless, I believe the channels are there, and you don't need lis pendens or res judicata or this type of legal ways to coordinate courts. This happens in I won't say magical way, but somewhat courts have the clairvoyance not to overstep boundaries and to somehow align themselves when they deal with same cases, with the same factual
There's also
matrix.
counsel who are appearing in the same court. There's overlapping counsel as well.
That's very important, yes,
Yeah.
what you're saying, yeah. The people are more or less the same, even though the judges are not. Yeah. So I wouldn't worry too much about this, and so to institutionalize or whatnot. Now, wow, okay, alternatives.
That's the big one to end on.
To the best of my knowledge, no. We don't have a new radical proposal as to how we should restructure this.
Well, there's Mark Carney, you know.
Yeah, but
let's have a middle power coalition.
He does not propose an overhaul of the value system, let's say, that we've built upon, if that's what you meant. How can you deal with authoritarianism? Yes, I agree that the proposal is good enough to know your alliances, know where you, if you're a state, I mean, know where you stand, and to be on the right side of history, which, I mean, means that you have to make the necessary value judgments in this respect. Again, I cannot say anything beyond that, apart from the fact that, you know, upholding the international rule of law is a must today. So.
Well, join me in thanking Nick for an incredible conversation, and also congratulations on an excellent book.
Thank you.
You.